Senator Mills, Robert Mills, now calls from the calendar Senate Concurrent Resolution Number 14 by Senator Robert Mills. It's a concurrent resolution to suspend until 60 days after final adjournment of the 2021 regular session the provisions of Title 32 relative to the exclusion of evidence of failure to wear a safety belt.
Senator Mills.
And I believe we have an amendment.
Amendments sent up by Senator Mills. They are set number 307. 307.
On the amendment.
Thank you, Mr. President. And members, the Senate Concurrent Resolution number 14 is amended to effect that the suspension itself will be dissolved in the event that Senate Bill 57 is signed into law. So this suspension that I'm going to propose to you will expire itself if Senate Bill 57 is signed into law. So this may never go into effect. This may go into effect for a very short period of time. We don't know, but it is tied to that particular action, which would hopefully we will present to the governor a good 57, and hopefully the governor will sign it. There's some risk that won't happen, so the amendment will solve that problem. I've got a question.
Before you do, Senator Mills, I want to make sure everybody understands you referenced Senate Bill 57, but it appears the amendment says House Bill 57.
Yeah, House Bill
so
57.
Senator Luno has a point of order, though, if you allow him to state his point.
Thank you, Mr. President. I rise with a point of order on two issues, Mr. President. One is to determine the vote, if it's a two-thirds vote that's required or a simple majority. And secondly, to request whether this resolution is outside the items listed in the call for the special session.
Okay, let me take a look at it, Mr. Parliamentarian. Okay, Senator Luno, after discussion, it appears that Constitution Article 3, Section 20 says that the legislature may suspend a law and then only by the same vote as it was passed. So the bill was passed would be passed with a majority vote, so the suspension of it would only require a majority vote. To your second point, item number 40 in the call allows to legislate with regard to civil liberty and motor vehicle liability coverage, general prescriptive periods for intellectual actions, collateral source, prescription, jury trials, jury trial thresholds, direct actions, evidence regarding seatbelts. And so this deals with the evidence regarding seatbelts. So I'm going to go ahead and rule that it is a majority vote and it does fall under the call. Okay. Senator Mills, so we're back on the amendment, I believe. So go ahead and state the amendment again. Tell them what it does.
The amendment that we have in front of you at this point in time would, I guess, terminate this suspension resolution in the event that House Bill 57 is signed into law. And there may be an amendment to the amendment proposed to us in just a little while, but the amendment is just to close out this suspension in the event that House Bill 57 does become law.
Okay, we have some questions. Senator Hewitt for a question on the amendment.
Yeah, thank you, Mr. President. Senator, I like what you're doing with the amendment. The only thing I was going to ask is, I have a seatbelt bill that was just passed by the House, so it's on its way to the governor's desk, and that is the repealer language that's identical to what's in House Bill 57. So I guess I am asking if you'd be willing to put this temporarily back on the calendar for a couple of minutes and give me a chance to offer a different amendment that would include both the Speaker's bill and Senate Bill 9 in this amended language.
That makes sense to me. We talked about it and I understand that, and that'd be fine with me.
Okay. I mean, I'll work on it right now if we can just have a couple of minutes.
If you'd like, we have other questions and we have people to the floor on the bill. So if we get through with all of that and we haven't gotten your amendment ready, we'll temporarily return it. But I think we can go ahead and debate while you're preparing your amendment.
Thank you.
Okay. Senator Luno, did you want a question on the amendment? He waives. Senator McMath, a question on the amendment?
Thank you, Mr. President. Senator Mills, just to be clear, so this is going to be contingent upon veto of Senate Bill 57.
If for any reason House Bill 57 does not go
House
into
Bill
law.
57,
Yeah,
excuse
House
me.
Bill 57 does not go into law. The suspension rules, and it continues on for the term indicated. If House Bill 57 becomes law under any reason, the suspension would go away.
And just to be clear, I believe we just found out that the House did not concur with the Senate amendments to 57. It's therefore going into conference. Is that correct? Is that how I understand it?
That's what I heard.
Meaning, I guess, the content of House Bill 57, we're in its final form, we're unsure of what that would look like.
I'm living on faith that House Bill 57 will end up a good bill, and if so, and is signed by the governor, I concede that we'll let the suspension die.
Okay. Thank you, Senator.
I'm being told up here that House Bill 57 did get rejected in the Senate amendments, and it will go to conference, so there will be another opportunity for this Senate to vote on the conference report if it were to come out of conference, just to kind of
Yeah, I guess.
educate the
Okay.
members.
Thank you, Mr. President. Thank you.
Okay. Question from Senator Luno.
Thank you, Mr. President. Senator Mills, what provision in the Constitution or statute allows for a suspensive condition in a resolution?
I spoke to the Attorney General this afternoon, and he was very comfortable that this issue is constitutional coming in front of you today, and I would rely on the advice of the Attorney General.
I'd be more comfortable if I knew, because I can't find one, and I don't know that it is. I don't know that we've ever done that before, but that would be a big concern, I think, of a lot of people, because you're looking at a potential constitutional battle that would cost the state of Louisiana a lot of money over that. So that's why I'm asking. Did the Attorney General tell you this is the provision that allows that?
I'm not going to speak for the Attorney General. I'll tell you what he said, and I'll ask you to contact him and discuss that in great detail as far as you want.
Well, we're voting on this now, so I don't have the opportunity to do that.
That's all. Again, I'm not.
It's okay if you don't know. I understand. You don't know what it is?
I'm not going to represent what he said, other than it is constitutional.
Did he tell you what provision he thought allowed this to happen?
I took some notes.
Okay, and you can't share that with me, what provision it is?
I'm not going to get into discussion with you on it, no.
I'm not asking you to get in discussion. I'm just asking
Yes,
you to tell
you
me
are.
what. Okay, let me speak, sir. I'm just asking you to tell me what provision in either the Constitution or a statute allows us to do this.
The answer to your question is the Attorney General says it's constitutional.
Thank you, sir.
Senator Peacock for a question on the amendment.
Thank you, Mr. President. I thought I'd come up here and ask you a question. And I was going to ask this question tomorrow in committee, but since we're here and we have this language and we've got some time on the floor to visit about it, it says it's not enacted or is vetoed or fails to become law. So does the fail to become law if, say, the courts say this is litigated and it goes to the courts and the courts say no on the bill, on House Bill 57. For some reason, there's a technicality. The chairman of Jude didn't do his job, which I hope that never happens. But say something like that. It's my fault. I've heard that before from someone. So if the courts say that 57 in law isn't right because of dual object or whatever claim would this resolution suspend the law if the courts decide? Did the Attorney General give you any guidance on that?
We did not speak about that, but the amendment says that if the House Bill 57 does not become law for any reason, and that in this case would include the scenario you say, and this suspension would go into play and would be with us until.
Okay, so that's the
termination.
understanding is if it doesn't pass conference,
Yes.
if it gets vetoed, if it is struck down by the courts, this resolution goes into effect.
This resolution will go into effect.
If it does not become law.
It goes into effect. as soon as the legislature approves it by majority vote.
Okay.
And it dies only upon the effective implementation of House Bill 57, or as amended by Senator Hewitt.
And that's going to be a Senate bill. So as you mentioned earlier, Senate bill, House bill, it's going to have both of them in there, right?
Tell me that again.
That's a Senate bill, so you're going to amend as you mentioned, if a Senate bill doesn't pass or a House bill, both of them don't pass.
It has to pass both houses.
Okay, good. Thank you, Mr. President.
Thank you, Senator Peacock. Okay, Senator Mills, it appears we have no more questions on the amendment. Is there any objection to the adoption of the amendment? And we do have an objection. Senator Luna, would you want to come state your objection?
Members, I object to this amendment because it clearly provides a framework for a constitutional challenge when you get up in this mic and you say your stated purpose is to thwart the veto power of the governor. That's an overlap of the judicial and the executive branches of government, and this will open up to a challenge on the constitutional basis that we can not afford to incur.
Okay, Senator Mills, you have a right to close on your amendment.
Senator Mills now calls Senate Concurrent Resolution Number 16 by Senator Robert Mills. It's a concurrent resolution to suspend until 60 days after final adjournment of the 2021 regular session of the Legislature of Louisiana, the Code of Civil Procedure article relative to the jury trial threshold for petitioner's cause of action.
Senator Mills.
And we have an amendment for this Senate Resolution 16 as well.
Amendments sent up by Senator Robert Mills. They are set number 323. 323.
On your amendment.
The amendment, just as we discussed a minute ago on 14, sets a point that this suspension, if passed by both houses, legislature, would expire at the initiation, at the enforcement of House Bill 57, and it'll be, at that point, the suspension will go away. But so that's exactly what it does. The suspension would be in effect until the termination of it, unless House Bill 57 is signed into law.
Okay, Senator Mills, we have a point of order by Senator Jackson. Senator Jackson, do you have a point of order? Yeah, come down and state your point.
Going through on yesterday when these were introduced and scheduled to be heard on whether or not, my point of order is this, is I've never seen this type of suspension resolution that usurps a constitutional power of another elected official. I've read over it. I'm not sure if it's appropriate, so I'm asking the chairman, Mr. President, on whether it's appropriate to have a suspension resolution that generally usurps the constitutional power of another elected official, because I'm hearing testimony that this is being done to make sure that the governor's veto power is, usurped.
Let me get my parliamentarian up here again. Okay, Senator Jackson, I'm being told that the Senate and the House have traditionally done suspension resolutions for many, many years of the laws they've enacted.
Right.
This does not have anything to do with the override of a veto. It simply has to do with the suspension of a law, not the override of a veto. So I'm told, and I believe in my time here, that we have done many of these suspension resolutions, and it's simply addressing a law that was passed by the legislature, and it is now taking the same vote to suspend that law.
Yeah. And I guess maybe the testimony gave a misconception that it was usurping the governor's veto power. Thank you.
Thank you. Okay, so Senator Mills, you get a question on the bill, not on the amendment. Okay, is there any objection to the adoption of the amendment? Seeing no objection, that amendment stands adopted. Okay, Back on the bill. For a question on the bill, Senator Mills, Fred Mills.
Thank you, Mr. President. Senator, so the jury threshold would be at 0?
0.
So I want to go to city court to 500 small claims with a business issue. There could be a jury trial on a $500 claim in city court?
If you ask for a jury trial in America, you should be able to get one, and you'd have to go to a different court, but and get in line.
You might want to talk in the mic.
Yes, the threshold would be 0, and if you requested a jury trial, the city court would not be able to accommodate you. You'd have to move it to another court.
But you still, okay, I see what you're saying. Thank you.
Yeah.
Thank you, Mr. President.
Thank you. Question, Senator Lambert.
Senator Mills, you're suspending 1732-1, is that correct?
Yes,
Okay, could you tell me what that says?
I can read it to you. And it's got several parts. The trial.
Well, all we're doing is section 1, correct? Okay, read it to me.
A suit where the amount of no individual petitioner's cause of action exceeds $50,000 exclusive of interest and cost, except as follows. And it goes into A. If an individual petitioner stipulates or otherwise judicially admits 60 days or more prior to trial that the amount of the individual petitioner's cause of action does not exceed $50,000 exclusive of interest and cost, the defendant shall not be entitled to a trial by jury. B, if an individual petitioner stipulates or otherwise judicially admits for the first time, less than 60 days prior to the trial, the amount of the individual petitioner's cause of action does not exceed $50,000 exclusive of interest and cost, any other party may retain the right to a trial by jury if that party is entitled to a trial by jury pursuant to this article and has otherwise complied with the procedural requirements for attaining a trial by jury. C, notwithstanding subparagraphs A and B of this subparagraph, if as a result of a compromise or dismissal of one or more claims of parties which occurs less than 60 days prior to a trial, an individual petitioner stipulates or otherwise judicially admits that the amount of the individual petitioner's cause of action does not exceed $50,000 exclusive of interest and cost, a defendant should not be entitled to a trial by jury.
Okay, so what you're doing is, so if we get rid of that, does it even talk, what happens to a trial by jury? Does it go to 0, or does it mean not necessarily anywhere else talk about a trial by jury?
Trial by jury is talked about in section 2, 3, 4, 5, and 6.
Okay, are you suspending those?
No.
So I'm not sure how this plays out, though. If you suspend that one, you're talking about the amount. Is that it? It goes to 0? Or does it, what does it do to this? Or does it just suspend the whole thing about a jury?
Jury trial threshold goes to 0 in the case of all those causes discussed in 1.
Okay, so how are the courts going to handle this? Right now we have a $50,000 limit?
Yes.
All right. How does this work now if we're going to have all of these cases? Are people going to have an opportunity to have their cases heard if you do this immediately?
In the other 36 states that have 0.
Yeah, but we're not talking about the other 36 states. We're talking about Louisiana, correct?
You're speculating about Louisiana, and all I can do is tell you that in the fact situation where this does exist, that the world turns and people get heard and more people settle cases, and it works out, and it's worked out quite well.
When you say about the facts, but you don't know the facts of what's happening in the other states. Who's paying for juries, whether it's state funded, whether it's paid by the plaintiffs or the defendants or the participants, do you?
I know for a fact that their jury trial threshold is 0. And
yeah,
that's
but
all
that doesn't tell who's paying them and who's taking the additional cost of doing this.
I did not speculate on who does.
Do you know how many judges the other states have to hear these cases?
I don't know the number. I'm not going to, not even try to represent you. I know the number.
I mean, don't you think it's right for people in Louisiana to have their cases heard in court? Don't you think we should have quick access to the judicial system?
You should have access, and you should have a trial by jury if you want a trial by jury.
All right, and what you're doing here, you're kind of upsetting the whole apple cart, aren't you? By throwing this on one time, immediately on the system?
Some people think that's a good idea.
Well, but it's not some people. What we're talking about is people having access to justice. So if you do this and somebody has a claim, whether it be a business person or whatever, and you're now going to require all these jury trials, even though this may be a business claim, are you now going to delay justice for those individuals?
Justice would be delayed if somebody wants a jury trial and the courts don't react to allow it in a reasonable period of time.
Do you know how long it takes to do a jury trial? Have you ever done one? You ever participated in one?
Fortunately, I've not had any direct experience, but I've heard testimony to the point, and it's time-consuming, it's expensive, and there's quite a process involved, and that's why people would have an option to settle their lawsuits, mediate their lawsuits, and avoid the wait. That's up to the parties. It's not.
Don't they have that option now? They can arbitrate or mediate their suits?
They surely do. They just don't seem to.
So in other words, if I'm a business person and I have a contractual dispute now, and I have a good bit of money at stake, and it could mean my business going under or not, I'm now going to be delayed to going to court because we're going to have so many more jury trials. Is this what's going to happen?
I did not say that you're going to have many more jury trials. I can't speculate that.
But you're setting up the system where you're going to have a lot more jury trials and you're going to delay justice. Don't you agree with that?
No.
Why can't you agree with that?
Because I rely on the evidence of the other states that have a zero jury trial threshold, the number of cases that I've read
Okay, you
about.
rely on the evidence of the other states. Do you know how many judges they have? Do you know how they set up their systems?
I know that Louisiana is considered to have many,
That's
many
not my
judges per
question.
100. Well, I'm answering the question the way I need to answer it. That Louisiana is represented to me that Louisiana has many more judges per 100,000 population than other states. But
Who has represented that to you?
that's been testimony that was in the Senate Jude meeting the other day.
And who testified to that?
Again, there was quite a bit of testimony. I'm not going to try to, quote or represent that. But
So it's your opinion that this is not going to delay regular people going to court. What about divorce cases? Judges hear both.
Divorce is handled in 3, and it's not affected by this.
Yeah, but we're going to have jury trials because the judges are hearing jury trials. They're not going to be hearing as many divorce cases, child support cases, possible criminal cases.
Article 1732.3, which is not affected by this suspension, says a summary, executories, probate, partition, mandamus, habeas corpus, quo warranto,
No.
injunction, marriage or divorce proceedings.
Okay, but judges hear criminal cases in my judicial district. They hear divorce cases. They hear business litigation cases. If they now have to do all of these jury trials, how are they going to balance this and do these other cases? Are these people going to be delayed justice?
You're assuming different things than I am. You're assuming there's going to be many more jury trials, and I'm not assuming that there's going to be. I can't speculate there's going to be more jury trials, and I'm supporting this suspension in any event.
So you're supporting it no matter what it does to the rest of the judicial system. Is that what you're telling me?
I contend that we don't know exactly what it's going to do to the rest of the judicial system.
How many hours do you have in a day?
There's 24 in mine.
Okay. It's 24 in a day. How many days does a judge have? How many hours does he have to hear cases? If you're going to have jury trials, which by your own admission take much longer, how is he going to hear these other cases?
They're going to have to make provisions to do that, and I'm sure.
How
that
can
they'll
you
work.
make provisions when there's only so many hours in a day?
I'm not going to tell a judge how to do his business, but they're going to have to make provisions to handle the workload, and I feel certain they'll do that.
All right.
Thank you. Senator Gatti for question.
I appreciate the spirit of the resolution and the attempt to do something. The concerns that I have, and sometimes I tend to live too much in the hypothetical, but look, and you've heard me give the story of my good friend back home that has the landscape company that clipped mirrors with the guy. 6 months later, he gets sued. So what happens if we vote on this today and the SCR has the power for a year? So what happens if that happens next April and he clips mirrors and 6 months later he gets sued, which is beyond the year from today? What's in action? Is it this resolution because he had the accident while the resolution was enacted, or is it the law that's in place after the resolution ends? Look, I'm not an attorney, and thank God I'm not. Look, I got a brother, and I told him to go find another job.
Then that's a very good question.
That's my concern.
That's a very good question for an attorney. I'm not an attorney, and we've got several in the room. I'm sure they'd be glad to speculate if you need them to, but I can't answer that question.
Okay, I mean that's my reservation that I have is the what happens beyond the 12 months. So anyway, thanks.
Thank you. Senator Johns for a question.
Senator Mills, I've been here a long time, and I've always been an advocate of trying to lower the jury threshold to a reasonable amount. But I think you've answered it a couple of times, but I'm going to ask one more time. This is going to take it to 0. Is that correct?
That's correct.
So my neighbor's dog comes into my yard, and he damages my expensive patio furniture.
I hate it when that happens.
And he's liable. We're liable for what animals do. I'm in that business. So the damage is $500. I decide I want to take that to a jury trial. I can do that?
If you demand a jury trial in America, you should get a jury trial.
Okay, I can take it to a jury trial. You have any idea what it's going to cost the insurance company to defend that in a trial?
I can't speculate what that would be.
I'd say $10,000 to $15,000 minimum. Unless Senator Luno was handling the case, it may be $25,000 then. So, but the point I'm trying to make, and I applaud what you're trying to do, but I think ultimately you're going to raise insurance rates. Honestly, I think it's just, I think there's a fine line there where you set the threshold or take it to 0. And I think that's where your resolution's problematic.
Well, again, your scenario was an extreme one, and
But
all parties would be disappointed if you have to go to a jury trial over a patio furniture. But I can't say that wouldn't happen.
No, I mean, I use that as kind of a humorous
and the same
example,
thing
but it could be anything.
And it could apply to a $2,000 situation or a $3,000. There's situations that,
could be a bad check somebody wrote me or
it
something.
surely could.
Yeah.
Yes,
So
sir.
anyway, I just wanted to make that point. I think you're actually going to make insurance companies spend a whole lot more money in the long run than they should be having to spend. And of course, that goes into the rating factor, as you know.
There's an insurance company represented in the audience if you want to go visit with Joe Mapes, and he would disagree with you. But
Senator Mills, I've been doing this for 39 years. I only got 2 more months, and then I'm out of there. But if I can't debate a whole lot of things in this body, but I can debate insurance. So, thank you very much.
Thank you.
Senator Connick, your question.
Thank you, Mr. President. Senator Mills, does this apply to the Justice of the Peace Courts?
I don't know off the top of my head.
Okay, but this is your bill, right?
That's correct.
Okay. Did you have any input from the Supreme Court about how this will affect justice in Louisiana if this passes and if it goes into effect?
I received a letter late this afternoon, and I'd have to,
You would agree this would destroy a third branch of our government?
that's not my intent. I received a letter from Louisiana State Bar Association. I don't believe I have any information from the Supreme Court.
They're against the bill, correct?
Pardon?
They are against the bill?
Their letter is lengthy, and yes, they would be
concerns.
against this bill.
Did you have any, before I said that, you like zero jury thresholds, correct?
In this case, this suspension would take it to 0. That's correct.
And you think that works, right?
If that's all I can get, that's what I get.
Okay. And do you know Maine has a zero jury threshold?
Just say again.
Maine, the state of Maine, has a zero jury threshold. They do.
I trust you.
And you know what the prescriptive period is?
No.
6 years. So if you can't settle your case in 6 years, then you have a jury trial. The yin goes with the yang, and this is only the yin, and I don't think it's going to work. Because you are lowering the jury threshold, but you're not extending the prescriptive period. Does that have any concern to you?
My concern is if we don't do anything, nothing will ever change, and I'm willing to fight for change.
Okay. Now, we talked about the expense of this bill. I looked at the fiscal note. There's a note that comes from the AG, who I think appears to be involved in this legislation. And the Office of Risk Management. Where's the fiscal note on how it's going to affect the local parishes, the clerks of court?
We asked for a fiscal note, and you have it in front of you, and that's all I can tell you is what we received.
Who testified in committee about the effects this passage of this legislation would have on the clerks of courts in Louisiana?
Specifically to the clerk of courts, you tell me. I'm not going to try to recite that.
I don't remember her name, but I saw her come up and said if this passes, you're going to have jury trials take place. What she told you?
Well, it was private.
Okay. But didn't she say that if someone asks for a jury trial and they lose and they're going to have to pay the cost, and if they don't pay the cost is going to be borne by the parishes, correct? You remember that testimony?
Well, she was testifying about the effect on the clerks, and I'm not going to tell you what her testimony was. It was in the record.
Okay. Do you recall it?
I recall her testimony. I don't recall it verbatim, and I'm not going to speculate that she was correct in her assumptions.
Okay, but she is a clerk of court, and she does this day in and day out, and she knows what it takes to put on a jury, and she knows the expenses of that, and that's what she testified to, and I think it was that it would be a negative impact on the parishes to allow a zero jury threshold during this time. Would you agree with that?
The record would reveal that, I'm sure.
Okay. Are you proud of this bill?
I'm going to carry something home when
Okay.
this session's over, and if this is all we get, this is all we get.
Can we name this the Robert Mills tort experiment of 2020?
If that's what you want.
Whatever you want, sir.
Well, I just want passage of this suspension. I don't need any accolades, but thank you for offering.
All right, thank you.
Okay, Senator Morris for a question on the bill.
My good friend Jay Morris is going to talk, but we would go ahead and ask to return this to the calendar. We've got things to do.
Return it to the calendar without objection.
Thank you, Mr. President.
But I respect what you would have said.
It's the other 7 or 8 people for the question on the bill you'd have to get through. Okay, return it to the calendar. Thank you, Senator Mills.
Do we have our amendment ready for 14? Yes, let's do that.
Senator Mills now calls back up Senate Concurrent Resolution number 14 by Senator Robert Mills. It's a concurrent resolution to suspend until 60 days after final adjournment of the 2021 regular session the provisions of Title 32 relative to the exclusion of evidence of failure to wear a safety belt. And Senator Hewitt sends up amendments. They are set number 414.
Okay, Senator Hewitt, explain your amendments.
All right, thank you, Mr. President. This set 414 basically is just saying that this resolution will only take effect if House Bill 57 nor Senate Bill 9 get signed by the governor, get passed and signed by the governor. So we would prefer both of those bills to the resolution, but if neither of those bills ultimately become law, then this resolution would take effect. That's what this amendment says.
Is there any questions on the amendment? Senator Price for a question on the amendment. So Senator Mills, will you relinquish the floor for Senator Price to ask Senator Hewitt a question?
Thank you, Mr. President. Just for some clarification, so Senate Bill 9 passes and is signed, which is your seatbelt bill, and this
resolution,
HB 57 does not come into effect, say, then which one takes effect here? Your bill, Senate Bill 9?
yes, with this amendment, then the resolution would not take effect if either House Bill 57 or Senate Bill 9 become law.
Become law. Okay.
So, yes.
Thank you.
Thank you. Senator Jackson for a question on the amendment.
So I just want to make sure, because this amendment seems to, it changes the effective date. The original resolution said it was effective upon signature or something. But with your amendment, this resolution will only go into effect if the governor exercises his constitutional veto power.
I'm not sure about that.
Okay.
Say it again or ask me again.
Okay. With your amendment, your amendment says that the bill will only go into effect if both bills that you mentioned are vetoed?
Or they don't pass. I mean, my bill has, this SB 9 passed the House and it's on its way to the governor's desk.
That's your seatbelt bill.
Seatbelt bill.
And this resolution has the entire content of your seatbelt SB 9 in it. Doesn't change any provisions of it.
Correct.
Okay. And then you reference
House Bill 57, which is the speaker's, what we call the speaker's tort bill. As you know, has not passed yet. It's in conference committee now, I believe.
Right.
Okay. So, again, the amendment is written, the intent of the amendment is that the resolution would only take effect if neither of those bills passed or were vetoed. So if you don't have the preference is to have a bill over a resolution. So if one of those bills becomes law, then this resolution does not take effect. But if both of those bills are vetoed or never get sent to the governor's desk, well, then this resolution would kick in.
Now, your bill, Senate Bill 9, has passed.
It passed the House this afternoon.
And so it's on its way to the governor. So the only way that this resolution becomes effective is if the governor vetoes Senate Bill 9. Because otherwise, it's an either or. So otherwise, if the governor signs Senate Bill 9, this resolution would not be effective, right?
If the governor signs Senate Bill 9, this resolution would not be effective. Correct.
So I'm going to ask everyone the same question, because my concern was not that we're suspending the law. My concern with this amendment is now the concern I had when I first came up when we started the last resolution, is that it seems that these resolutions are being put in to usurp the governor's constitutional veto power when we have procedural mechanisms in place in both the House and the Senate to override a veto. So are we also, this resolution would basically usurp the House and Senate's ability to override a veto, right?
Well, again, I'm not speaking on the intent of the resolution. I'm
saying your
strictly
amendment,
trying
yeah.
to amend it,
Yeah.
right, to consider Senate Bill 9
Well,
and the
I
fact that
think-
it deals with exactly the same language as it relates to seatbelt as House Bill 57.
Yeah, and I'm saying the bill to your amendment, because before this, the bill didn't reference the governor's or our ability to pass legislation or the governor's ability to veto legislation. So your amendment now, if it is amended onto this bill or this resolution, basically ensures that we don't have an opportunity to override a veto, because that never happens because this goes into effect, and that basically the same content of the bill that just went up to the governor will still become law with this suspension resolution?
My understanding of the resolution, and again, it's Senator Mills's resolution, but my understanding of the resolution is that it would suspend the law for, 1 year plus a few months.
The same law that you changed in Senate Bill 9.
Right.
And so that's what I'm saying. Basically, with this language, is now making a contingent upon what happens with Senate Bill 9.
Senate Bill 9 is included now, yes, because it has the exact same language as the seatbelt provision in HB 57.
Thank you.
Thank you. Senator Peacock for a question on the amendment. Senator Peacock?
Thank you, Mr. President. I was just, the wording of this amendment, I wanted to make sure, because it says if either is enacted or if both are vetoed. So it was very confusing to the wording. It says enacted if neither is enacted, or if both are vetoed. Is that the? Okay, it's just it's not very clear reading that. Okay, but it says enacted or if both are vetoed. So I just want to make sure the terminology. Thank you.
All right, there are no more questions on the amendment. Senator Hewitt, you have a right to close on your amendment.
I'm going to ask for your favorable passage. Thank you.
Was there any objection to the adoption of the amendments? Senator Barrow, you object? Okay. So Senator Hewitt has offered up amendments to which Senator Barrow has objected. When the machines are open, all those in favor of adoption of the amendment will vote yes. Those opposed vote no. And the Secretary will open the machines. Vote your machines. Senator Marsh, yes. Senator Cathy, yes. Senator Robert Mills, yes. Senator Talbot, yes. Senator Tarver, no. You through voting? Senator Johns, yes. Okay, close the machines. 22 yeas and 16 nays, and the amendment stands adopted. Okay, so we're back on the resolution itself. Okay, to the floor on the resolution, Senator Luno.
Thank you, Mr. President. Members, I rise in opposition to this resolution, not so much due to the content of it, because I don't totally disagree with that. I think that there's room for legitimate debate there, and I can see the merits in some of the content. But I rise in opposition due to the method employed by suspending the existing law in the state of Louisiana. This procedure that we're talking about here today, the resolution, is often used to suspend things like taxes, which apparently is a method approved by a vast majority of this body. It's not normally used to repeal a statute just because you can't get the bill that you preferred signed by the governor. Now, in the Constitutional Convention that drafted the Constitution we operate under today, this exact issue was debated. And the reporter from the Constitutional Convention talked about it this way, and I quote him. In further support of Delegate Casey's statement, a number of delegates spoke of the exercise of the suspension power to rectify mistakes made by the legislature originally in a particular piece of legislation. The reasons delegates forwarded justifying the use of the suspension powers were to address emergency situations, to address unconstitutional sections of the legislation, and to prevent injustices and other undesirable consequences. The majority concerns of the delegates involved possible abuses of the power by the legislature through its exercise of an almost unlimited restraint to pass suspensions when compared to the passage of bills. So what does all that mean? That means that the constitutional framers addressed this issue and said, we don't want you using it the way we're trying to use it today. So why are we doing this procedure now? Why are we following this procedure on these resolutions? Well, it's clearly not to create certainty, because it's going to create a lot of uncertainty. And the one thing we have heard in just about every committee we serve on, whether it's insurance or Jude A or any other committees, is that businesses want certainty. They want to know what's happening. So what's going to happen here if we pass this resolution today? What's the certainty going to be? Well, does it mean that we go back in all of these cases that deal with a seatbelt issue, and do we reopen discovery? Do we allow for the employment of new additional experts? I would say that it would quite likely they would have the right to do that. But what if one circuit says we can do that and another doesn't? Well, how does that happen? What happens when the courts of appeal disagree? It ends up at the Supreme Court. And this will end up there, and it will be litigated, and it will take quite a while to go through all of this mess. And then whichever way the court rules, the rest of those cases are going to have to come back down and either be tried again or some adjustments made so they can provide with the provisions that are ultimately found by the Supreme Court to be correct. During my tenure as a senator, and quite frankly, for as long back as I can remember being involved in this process, the Senate has been the voice of reason. We have ensured that the process was fair and that the process was reasonable, even when it meant that the outcome we wanted was not what was achieved. But the process is important, and that is why it is not a reasonable way to suspend these particular laws and these three resolutions in the manner in which we were seeking. Therefore, I ask for your opposition to this resolution.
Thank you, Senator Luna. Okay, Senator Mills, there is no one else on the floor. You have a right to close on your concurrent resolution.
Article 3, Section 20, that the framers wrote, what they published, their last word on the issue, without any further oration or limitation, says exactly this. Suspension of laws, Section 20. Only the legislature may suspend a law, and then only by the same vote, except for gubernatorial veto and time limitations for introduction, according to the same procedures and formalities required for enactment of that law. After the effective date of this Constitution, every resolution suspending the law shall fix the period of suspension, which shall not extend beyond the 60th day after final adjournment of the next regular session, period. No further advice, no further criticism, no further discussion of what you can and can't do. It's very direct, it's very straightforward, and what I'm asking today is that concurrent resolution number 14 be passed by this body, sent to the House, let them discuss it, and let's move forward with something that maybe isn't the prettiest thing, maybe isn't the ugliest thing, but it's action, and this body cannot be held hostage by another branch of the government. We have equal power. Let's exert our power. And I ask you to vote in favor of Senate Concurrent Resolution 14. Thank you.
Senator Mills has moved final adoption of Senate Concurrent Resolution 14. All those in favor will vote yea. Those opposed vote nay, and the Secretary will open the machines. Vote your machines. You through voting? Close machines. 21 yeas and 17 nays, and the resolution stands adopted.
Thank you.
Senator Robert Mills now calls Senate Concurrent Resolution Number 15 by Senator Mills. It's a concurrent resolution to suspend until 60 days after final adjournment of the 2021 regular session of the legislature the provisions of Title 22 relative to the right of direct action against an insurer in certain circumstances. And Senator Mills sends up amendments.
Okay,
They're
Senator
set
Mills,
number 321.
on your amendments.
Identical to the first amendment we spoke of. This amendment stipulates that this suspension goes into effect upon passage by both bodies, and unless House Bill 57 is signed into law. And so that's the first amendment that we had proposed.
Senator Morris for a question on the amendment.
Senator, thank you, Mr. President. Mr. Senator Mills, the purpose of this amendment, at least in part, is to pressure the governor to sign House Bill 57, is it not?
Those are your words. I'm just saying that there's no reason to, if we have a good bill, it's signed into law, this is not required, this should go away.
Well, if the resolution is good on its own, why tie it to House Bill 57?
House Bill 57 will have been viewed by more people and approved by more people than this, I would assume.
Right, but if the resolution is what you want to pass, why tie it to that? What's the purpose of it if not to pressure the governor to not veto the bill?
It's to be sure that when I go back to my constituents that I said I tried and I did everything I could to put good bills out. And if the bills that we consider good don't,
You can try without tying it to a veto. Why tie it to the veto?
I would prefer for a full-bodied document such as we hope House Bill 57 ultimately.
You would
turns
prefer
into.
House Bill 57.
I would prefer that, but I'll be glad to have this if that's all I can get.
But do you think, by tying it to that veto, do you think this will pressure the governor to sign?
You'd have to ask him. I'm not trying to pressure the governor. I'm trying to give myself something.
I can't envision another reason for tying it to that.
You can speculate all you want.
Okay. Well, if that is the thought, you don't know John Bell.
Okay, there are no more questions on the amendment. Is there any objection to the adoption of the amendment? Senator Jackson objects. So Senator Robert Mills has offered up an amendment to which Senator Jackson has objected. When the machines are open, all those in favor of adoption of the amendment will vote yea. Those opposed vote nay, and the Secretary will open the machines. Vote your machines. From Robert Mills, yes. Senator Connick, no. Senator Tarver, no. Close machines. 19 yeas and 19 nays, and the amendment fails to be adopted. Back on the resolution. Wait, hold on. We got another set of amendments.
Another set of amendments by Senator Cathy. They are set number 394.
Senator Cathy, on your amendments.
So my amendment removes B and C from 1269B1 from the resolution, which is, it's the same language that we had in 418, where the insurer is insolvent and the service of citation or other process cannot be made on the insured.
Okay, are there any questions on the amendment? Is there any objection to the adoption? And Senator Mills, do you object?
I object at this point and ask that we just go ahead and move this to talk to you about it another day.